We are here tonight at the People's Law School, and I thank all of you for coming. I want you to know our next speaker is Connie Glass. Well known, the most popular of all of our programs, the most requested throughout the state of Alabama. She, in fact, was here two or three weeks ago, and y'all asked her so many questions about these nursing homes that she didn't even get through halfway through her speech. And I want you to know that what I've asked her to talk about is wills, estates, and trusts, because everybody is going to die, and you all need to know about these wills and estates and trust planning. Not necessarily just the nursing home issues, but all these other things. By the way, Connie Glass, she's an excellent lawyer. I think she's got the market on elder planning and that kind of thing. Of interest, she and our speaker next week, Bobby Prince, were the trial advocacy instructors at the University of Alabama when she was in Tuscaloosa for several years. You'll meet Bobby next week, and tonight you'll get to talk to Connie Glass again, and she's going to talk to us tonight about estate planning. Connie Glass, thank you so much for coming. Yes, ma'am.
Tonight we're going to talk about some estate planning issues. These issues apply to everybody. Everybody in this room, everybody that's listening. Estate planning applies to each and every one of us. We all have an estate. Some of us have little estates, some of us have medium-sized estates, and some of us have large estates, but we all have one. We're going to die with something. It may be the clothes on our back, but we've got something when we die. We also, many of us are going to reach the point in our life where we become incapacitated and need management during our life. So we're going to talk about all those kinds of issues tonight. But before we get into that, I want to give you the opportunity, if any of you did not get to ask your question about nursing homes, Medicaid, nursing home issues, now's your time. Does anybody want to ask any follow-up questions to nursing homes, nursing home Medicaid, who pays if you go to the nursing home, what happens if you go to the nursing home? There is a question.
What is the difference between a Medicare supplement and a Medicare Advantage plan?
It's a great question. The difference between a Medicare supplement policy and a Medicare Advantage plan. Medicare supplement is just a private insurance that you buy to supplement your Medicare insurance. Medicare has three parts. There's Part A, Part B, and Part D. Part A and Part B cover hospitals, doctors, and then Part D covers prescription drugs. Part A and B have deductibles. When you go to the hospital, there's a Medicare deductible. When you go to the doctor, there's a Medicare deductible. Your supplement insurance covers those deductibles and copays. A Medicare Advantage plan is a managed care type of Medicare. It's not the traditional A, B, and D. It is a like a PPO, like a managed care that you opt into. You have to opt out of regular Medicare and opt into Medicare Advantage. So it's an entirely different form of Medicare. You have one or the other. You don't have both. Okay? All right, anybody else? Questions about Medicare, Medicaid? All right, let's jump into estate planning. All right, let's talk about what an estate is. The word estate has a lot of different meanings depending on what you're talking about, whether you're talking about the IRS, whether you're talking about the probate court, whether you're talking about the nursing home, the estate. An estate, someone's estate, has a lot of different meanings. In the broadest sense, the word estate refers to anything that you own or in which you have any sort of interest. So that's, in very general terms, what your estate is. In identifying your estate for estate tax purposes, a taxable estate right now in the year 2014 is an estate that is worth more than $5,340,000, $5.34 million. A non-taxable estate is anyone whose estate's under that amount. So for most of us will have non-taxable estates, estates that are not subject to estate tax. Okay? Right now, the estate tax limit is $5.34 million. Okay? The estate tax, the taxable estate for estate tax purposes includes a lot of different things. It includes more than just what are probate assets. It includes essentially anything you own. So, for example, life insurance proceeds, that's a part of your taxable estate. So, if you happen to have a $5 million life insurance policy, it's very possible that you might have a taxable estate. But again, for most of us, that taxable estate is not an issue. Estates that are over $5.34 million are subject to estate tax. Estate, and I'm not saying state, That's estate tax, E-S-T-A-T-E. All right, so let's identify non-probate versus probate assets, because that's where most of us have questions. It's a really common belief that if you've prepared a will, then that will is going to cover everything that you own at your death, that it's going to control the disposition of everything you own when you die. And that's not true, because many of us have assets that are owned such that the will just won't control them at all. Those are called non-probate assets. So let's talk about what those are. What are non-probate assets? Assets that are owned jointly with right of survivorship are generally non-probate assets. What that means is if you own an asset jointly with right of survivorship with another person and you die, then the other person owns that asset outright. It passes by the nature of how it's owned. That happens very frequently with real estate. If you're married and you and your spouse own your home, it is very likely that you own your home as joint tenants with right of survivorship. So what that means is in the deed, there's language to the effect that the property is owned by you and your spouse jointly, and upon the death of either of you, then to the survivor. So when one of you dies, the survivor automatically owns the entire interest in the property. You don't have to do anything to make that happen. It's just simply automatic when one dies. Now, when it ends up in the estate of that survivor and they're the only owner, then when they die, it very well could be a probate asset at that point. But it's not a probate asset when there's a surviving owner. All right, with me? Bank accounts can be owned that way. Any financial account can be owned that way. Cars can be owned that way. So any number of assets can be owned as joint tenants with right of survivorship. Okay? It is very important, particularly with spouses, that you check the deed, the way the deed is written. A lot of people assume because both of your names are on the deed that it's a survivorship deed, and that's not necessarily true. You can have a jointly owned piece of property that is not owned with rights of survivorship. It can be owned as what's called tenants in common, which means that it's in both your names, but each one of you owns a 1/2 interest in that property. So it does, if it's a tenants in common interest, when one of the owners dies, that deceased owner's half is a probate asset and does pass through the terms of their will, okay? So if in order for it to be a survivorship interest, those survivorship words that I said earlier actually have to be written into the deed in Alabama. It's for and during their joint lives and upon the death of either of them, then to the survivor. So just because both your names are on there doesn't necessarily make it a survivorship deed. Yes?
In that example you just gave, what is the advantage of the way that would have been written?
The question is, what would be the advantage of a tenants in common interest? Let's say that me and one of my siblings owned a piece of property as tenants in common. That would be the way we would likely want to own it, because if I die first, I want my heirs to get my half interest, and he would want his heirs to get his half interest. Whereas if it was right of survivorship, whoever the last one of us standing would be the one to own it. So if it's non-spouse property, many times you do want it to be tenants in common and not a survivorship interest. And sometimes in second marriages, you may want a tenants in common interest rather than a survivorship, so it doesn't automatically pass to the surviving spouse. Yes, ma'am.
Give a simple definition of what probate is.
I've got a big old long section on that we're going to cover, so we're going to answer all your questions about probate tonight.
Yes, real quickly, is the right of survivorship for a spouse, for a couple that are buying a home? I mean, is that the default, or does that have to be specified?
Most often nowadays, that's really kind of the default provision. The question was, when a married couple's buying a home now, do lawyers kind of default to that joint with right of survivorship deed? That's fairly common now. Now, that wasn't so common 40, 50, 60 years ago. So you'll see a lot of old deeds that were done in the 40s or 50s, sometimes even in the 60s, that were not with right of survivorship. A lot of times those deeds were only in the name of the husband, and the wife's name wasn't even on the deed. But these days, it is most common that the lawyers default to that joint survivorship provision. They generally don't even ask. They just assume you want it, survivorship. Okay? All right, yes?
Is there some special words that goes on an automobile title to?
No, I'm sorry, I didn't mean to interrupt you, but the question is, are there special words on an automobile title? Generally on automobile title, it's John Smith or Sue Smith, so that either one of you have full right and title to that vehicle. So on that particular asset, it's the or language. Now that's not the way it is on a deed, but on a title to a car, it's John or Sue. So either of you would have full right and title to take care of the title to that property. The question is, if it's and, is it going to be a problem? It potentially could be. Cars and vehicles are one of the easiest things to change title to in Alabama, so they kind of have their own special rules. But technically, if it's John Smith and Sue Smith, it should require the signature of both of them. Okay? All right, any other questions about that joint survivorship language? Bank accounts generally are survivorship accounts. When both of you are on a bank account, if one of you dies, it will automatically belong to the surviving owner. Okay? That's not necessarily just with your spouse, it's also with your child. So if you're a widow, widower, single, and you've got your daughter's name on your bank account and you pass away, your daughter's the owner of that account. It's not going to pass under the terms of your will. And a lot of people don't realize that when they set up accounts with the child, the local child as an owner on those accounts, they don't realize that those accounts are going to pass automatically to that child, that one child. It's not going to be governed by the terms of your will. Okay? Joint ownership can also put an asset at risk during your lifetime, particularly if you've added a child's name to your account. You're opening up that account to that child's liabilities. So if you've got a bank account at XYZ Bank and it's your name or your daughter's name, and your daughter is sued or has some sort of financial difficulty and she doesn't have sufficient resources to pay her own liabilities, then that account is hers just like it's yours. So that opens up that account to her liabilities. So you have to be very careful when you add people's names to your bank accounts. Pay on death or transfer on death. That's another way to pass assets outside of probate. These are non-probate assets. POD or TOD, you may have seen that designation on a bank account. All that means is that when the owner of the account dies, that account's going to pay on death to whomever is listed as the beneficiary in whatever percentage the owner listed them. So I met with a family today, and his bank account was listed as pay on death to him and his 4 children. To his wife and his 4 children. So each one of them will get a check for 1/5 of what's in that account. So the wife gets a check for 1/5 and each child gets a check for 1/5. So it's going to pay to whomever is listed as the pay on death beneficiary. This is one instance where this is a better designation than just adding joint owners, because a lot of people will add all of their kids to their bank accounts. If you do that, then whichever kid gets there first can get all of the money out. Whereas if it's a beneficiary designation, no matter who gets there first, they're only going to get what they were designated to get. And you laugh. You don't think that happens, but it actually does happen when one child gets to the bank with a death certificate before the others get there, and they just go ahead and get all the money out and don't tell the others. I had several years ago a client who called me from out of town, and his sister had actually gone and cleaned out the bank account before she called him to let him know that mom had passed away. So don't think it doesn't happen. It does happen. What is a POD or TOD? What is a TOD? That transfer, it's just like POD. It's not payable on death, but transfer on death. And that's a normal designation for like a stock account where stocks transfer on death. So anytime you have a brokerage account or a stock account, it's going to be generally listed as a TOD, transfer on death. It's the exact same thing as pay on death.
So the POD or TOD does not have the liabilities you talked about earlier?
That's an excellent question. The POD or TOD, does that have the same liability problems that having a joint owner. You're exactly right, it does not, because that person doesn't have any ownership interest during your lifetime. That person only has an interest after you're deceased. So it never opens up that account to their liabilities. They only get it after you're gone. Whatever's left in it's what they get. Okay?
When a parent has a child that's 18, 20 years old in college, and the kid's buying a car from the parent, how should they title that car? Should the parent keep it in their name, the kid's name, both? How should they do that?
That's an excellent question. When you have an 18, 19, 20-year-old and that child is buying a car from the parent, generally you don't want to transfer title to someone who hasn't paid you in full yet for that vehicle, because if you know that if any of you've bought a car, the lien holder generally holds the title. The bank or the credit union is going to hold the title. So there's not a way to do that if you're an individual. So generally, you don't want to actually transfer title until the vehicle's paid for, because otherwise you don't have any leverage to get the vehicle paid for. However, when you're holding the title to the car and that child wrecks it and hurts somebody or there's a huge liability, then the owner of that vehicle could also be liable just as the driver of the vehicle. So there's kind of a toss-up there about which do you really want to do. Do you want to, I guess it depends on how good a driver they are. Do you really, or how much insurance you have. Do you really want to hold that title with that 19, 20-year-old driving it? Or do you want to go ahead and title it to them and just have them sign a promissory note to you? You don't actually have a lien per se on the vehicle because you're not a bank and a lien holder, but you do have a promissory note. Are you really going to sue them if they don't pay it? That's a whole other question. So for liability purposes, it's probably better to title it into to the teenager's name. Okay? Any questions? Other questions? Yes, ma'am.
On 401ks, does that automatically go to the spouse, or if they got children and stepchildren, does it get divided between, like the fifth story you were telling?
It's an excellent question. 401ks, does that automatically go to the spouse, or is it going to be divided among the spouse and the children? A 401k is going to pay to whomever is the designated beneficiary. When you set up a 401k or an IRA, they're generally going to ask you who you want to name as the beneficiary on that account. Any sort of retirement account should have a named beneficiary, because whomever that named beneficiary is can roll that account over. If it's a qualified retirement plan, they can roll that over into their own qualified plan, so they can stretch out the income tax, the distribution, so they won't owe so much income tax at one time. Because if that 401k pays out all in one lump sum, every dollar of it's going to be subject to income tax. So you want to be sure that you name someone who can roll it over so they can stretch it out over a number of years. But you can have more than your spouse named as a beneficiary. You could have someone else named. Now, most qualified retirement plans, the spouse is going to have to sign off on that. So the spouse would know if husband named his girlfriend as a beneficiary on that one.
Just making sure.
Not that I would think that would happen to you. All right, any other questions on beneficiary designations? Okay. IRAs, life insurance, 401ks, IRAs, annuities, any assets such as those can have a named beneficiary. Those are non-probate assets because they're going to pass outside the terms of the will directly to the named beneficiary. Let me give you one caveat here on naming beneficiaries. You generally do not want to name minors or disabled persons as direct beneficiaries. Okay? If you have a minor child, if you have a 12-year-old, 13-year-old, 15-year-old, you don't want to name that minor child as a beneficiary on your life insurance policy. The insurance company can't pay those funds to a minor child. So someone will have to go to court to get the authority to manage those funds for the minor child. So you don't want to name a minor as a direct beneficiary. Same thing with a disabled person. If you have a minor disabled child or even an adult disabled child who can't manage money, you don't want to name that adult disabled child as a direct beneficiary, because the insurance company is going to write them a check and they're going to hand them the money. Even though your will might say that you've created a trust for that disabled person, it's not going to pay to the trust if they're the direct named beneficiary. So you be very careful with that, because with children who are on SSI benefits that are needs-based benefits, you can cause them to lose their government assistance benefits by naming them as a direct beneficiary. So if you've got adult disabled children that you're planning for, you really need to be cautious about beneficiary designations. Okay?
And the age for minor is?
In Alabama, the age of adulthood is 19. The question was, when are you a minor in Alabama? And you're a minor until you're age 19 in Alabama. Okay? Revocable living trust, we're going to talk about this in just a second in more detail, but generally assets that are titled in a revocable trust are not, or titled in the name of a trust, are not probate assets. They're going to pass under the terms of that trust. Okay? So what is the probate asset? I've told you everything that it was not. A probate asset is one that is in your name only, that has no joint owner or no beneficiary designation. That is a probate asset and will be controlled by the terms of your will. Okay? All right. I'm going to skip estate and gift tax just 1 second, and I want you to jump over with me to page 6 on your outline. While we're talking about probate and non-probate assets, let's talk about what probate is. There's a question about that earlier, and I want to be sure I get to that. Probate is generally just the process by which you prove a will. If at your death, there's generally going to be a piece of paper that has your signature on it and a date and some witnesses, maybe a notary, and that's your will. All right? How do we know that's your will? How do we know that somebody just didn't concoct that document while you were on your deathbed? Or how do we know that the person you really left things to, it was not who this person wanted things left to, so they destroyed that will and did another one? There's no way for us to know that. We don't know the circumstances of how the will was done unless we were there. When Howard Hughes died, there were 60 some odd documents that purported to be his will. Different dates, different beneficiaries. Who knows? He could have done them all. We don't know. But the court had to figure out of all those documents which one is the real will, which is the valid will, the last will he did when he was competent. That's what the probate process is for. So what happens is, if there are probate assets when you die, somebody's got to probate your will. Generally what that person's going to do, he's going to go to a lawyer and he's going to say, you know, my Uncle Joe died and he's named me to be in charge of this will. What do I do with it? So what happens in the first step in the probate process is, who would we notify? We're going to notify everyone who would have inherited had there not been a will. Because those are the people that have an interest in knowing about this will. So if you would have inherited from Uncle Joe, if he had died without a will, but you're not included in Uncle Joe's will, then you have a right to know that he did a will, not including you, and you have a right to go in and figure out, was it valid? Did he know what he was doing when he did it? You know, what are the circumstances of his doing this will? So when a will is probated, the first step is for everyone who would have inherited without the will be given notice. Now, what if everybody's in agreement? That's Uncle Joe's will. We know it was his will. We all agree. Do you have to go to court? What happens? Well, all of those people who would have inherited, who have the right to have notice, can sign waivers saying, I know that's Uncle Joe's will. I don't care. Go ahead and probate it. Don't notify me. He left me out. I don't even want to know about it. So if everybody signs waivers, then the court can admit the will into probate without any kind of hearing and appoint the personal representative, used to be called an executor, to be in charge. Now, once that person is appointed, then they have a right then to collect the assets that were in the name of the deceased person, pay any debts of the estate, and then distribute those assets according to the terms of the will. So when you hear that assets are frozen for 6 months or you can't get to them for 6 months, that's generally not true. Because once the will is admitted to probate, then the person in charge can begin to collect those assets. Now, they collect them all into the umbrella of the estate, make sure they get everything paid that was owed by the decedent, by the deceased person, and then ultimately they're going to distribute everything according to the terms of the will. Okay? The only time that probate takes potentially a long time is if there are minors, disabled persons, or there's somebody contesting the will, or we got ornery heirs who won't sign waivers, just trying to be difficult. They can slow the process down. But generally, most of the probates I handle are over with in less than a year because everybody's in agreement. We all know that mama's going to get everything. Daddy left everything to her in the will. We're all in agreement that that's what's going to happen. So let's get it collected and get it to her. Get it all finished out. So most probates are pretty straightforward and pretty standard. It's the rare ones that I've got one coming up this week, actually. It's one of those rare ones, 124 heirs. It's my biggest one yet. Had a lady who died. She had no spouse, no children. Her will left everything to her parents, who were, of course, both deceased when she died. So what we have to do is we have to go back up her lineal line to her parents, out to their brothers and sisters, 8 on one side, 9 on the other. All of them are deceased. So then we have to go down the lineal line through all of these cousins and seconds and first twice removed or whatever they are. And unfortunately, this estate's been going on so long, some of them have died in the process. So then, that splits into even more parts. So 124 heirs, and we're finally closing that estate out this week. So those are few and far between. It's the first one I've ever had with that number of heirs in the estate. Where is a will probated? It's generally probated in the state where you're residing, generally in the county where you're residing when you died. There are some exceptions to that rule, but most often that's where a will is offered for probate. Now, if you die in Alabama and you own a property in Tennessee, what happens to that property? If it's probate property, your will has to be probated both in Alabama and in Tennessee. If you own property in Tennessee, Florida, and Georgia, and you died in Alabama, your probate starts in Alabama. There's an ancillary probate in Tennessee, an ancillary probate in Georgia, and an ancillary probate in Florida. Anywhere you have assets that are probate assets, your will's got to be probated in that state. Not in a county. Now, you could own property all over the state of Alabama. You only have one Alabama probate. But if it's outside the borders of Alabama, you may have to probate in other states as well as the process here in Alabama. Sir.
How do you avoid that?
Good question. How do you avoid those ancillary probates? First one's easy. Don't own property in other states. Get rid of it if you're not using it. We're going to talk about a living trust. That's an option for that. We're going to talk about that in just a minute. So if you'll hold that thought, I will cover that. Yes?
For a simple probate, can you individually do that by themselves, or is it need an attorney? Is it that sticky? Or?
That's an excellent question. Can you do a probate by yourself, or do you have to have an attorney to help you? If you know how to do the process, and you know the forms and all the documents that need to be filed and the things that need to be done, you can certainly do it by yourself. Now, in Madison County, where I mostly practice, and in most counties, the courts aren't allowed to practice law. The clerks are not allowed to practice law, so they're not going to walk you through the process. They can't hand you forms to use. So unless you know how to do the process yourself, it probably will be almost impossible for you to do it without legal assistance. So most people do hire attorneys to assist them with probate.
I have 2 questions. Is there a time frame in which a will can be contested? And then the second is, how long can an estate remain open so that people can still try to remove some finances from the estate, such as a hospital billed 392 days later, and is that estate still billable versus is it closed?
It's a good question. How long, the question is the 2 parts. How long does an estate remain open where creditors can come in and claim? And the other is, how long do you have to contest a will? The short, simple answer on will contest is 6 months. Now, there's exceptions to that, but generally it's 6 months. There's all kinds of exceptions to that rule, so I don't want to say you have to contest in 6 months. As far as claims are concerned, generally that's also 6 months. There's all kinds of exceptions to that. The lawyer who handles the probate, or whoever the personal representative is required by law to notify creditors who are known. So if the personal representative of the estate knows that there's potentially a hospital bill out there, and they don't notify that creditor, they don't notify the hospital that the person has died and there's an estate open that they can file a claim against, then that 6 months claim period is not really going to toll because the personal representative hasn't done his job by notifying that creditor. But if we've done all the appropriate steps of notifying all the creditors, running the creditor's notice, generally the claims period tolls at 6 months from the date the letters testamentary are issued by the court, when the will is admitted to probate.
Is the death announcement in the paper considered notification to everybody?
The question is a death announcement in the paper notification? Absolutely, unequivocally no. Absolutely not. Okay? Question?
Who has standing to contest?
Generally, the question is who has standing to contest. Generally, anyone who is an interested party in the will or in the estate, somebody who would have inherited but for the terms of the will. Most often it's an omitted person, like an omitted child or an omitted spouse or someone who's omitted from the will. Daddy left his estate to 2 children instead of 3. But there's no reason to contest if you contest and are successful and you're not going to get anything. So there's no point in contesting it if you wouldn't have inherited something. Does that make sense, what I'm trying to say? Question in the back.
Let's say that there's several inheritors or several beneficiaries to a will and one executor. How long can the executor wait before they probate that will?
The question is, there's several beneficiaries, and how long can the personal representative wait to probate a will? You can probate a will up to 5 years from the date of death. Now, if somebody in my life died and I was going to inherit, I wouldn't sit around and wait on them 5 years to get the will probated. Any interested person can request that the will be admitted into probate.
What about beyond 5 years?
There's some exceptions again to that. There's an exception to every rule. Have y'all figured that one out yet? There's always an exception to the rule. There's some exceptions if somebody withheld the will, defrauded, nobody knew the existence of the will. There's some exceptions to that. But generally, you have 5 years to admit a will to probate. That's the very general rule. Okay? All right. Who's in charge of probate? Whoever the will names. When you write a will, you always want to be sure that you have a backup person because a lot of times you can't be guaranteed that the first person you name is going to be alive and well and able to do the probate. So you always want to do a backup in the will. And I'm just going to give you my rule. Don't name 2 people to be in charge. Name 2 people to be in charge. Do not do co-personal representatives. I've got 3 estates right now with co-personal representatives, and I wish to goodness the person had listened to me and not done that. It never works out. 2 people can never get along to handle a probate. And I say that, of course there are people who do, but particularly when you've got 2 people who live in 2 different states, you're just asking for the probate to take twice as long when you put 2 people in charge because they have to sign everything. It's not an either or. When you've got co-personal representatives, they both have to act together. Just choose a person. For those of us who probate estates, just choose one person to be in charge. Doesn't matter to me which one, but just choose one because co-personal representatives, it's always difficult to make that work.
If you've named a certain person to be your executor, that's the person that handles the probate. What if something happens to them before you pass away? Do you have to change your will then to name a different person?
That's an excellent question. The question is, if you've named somebody to be personal representative and they die or become disabled before you die, what happens? Do you have to change your will? You will if you've not named a backup. But if I did the will for you, and most lawyers who do wills will tell you to always name a backup in your will. So if you've named your spouse, I'm going to ask you, what if that person's not living? Who do you want to be the personal representative of the will? So you can name as many backups as you want. We can go down the line. We can have 4 or 5 if you want to. But at least name at least one person as an alternate to the first person that you name. So that in that very unusual circumstance, what if the 2 of you are killed together? If you don't have an alternate, then there's no personal representative and the court has to appoint someone.
Can you name someone that lives in another state as your executive?
It's an excellent question. Can you name someone that lives in another state as an executor or personal representative of your will? You absolutely can. Now, if you don't have a will, you die without a will, if you die intestate in Alabama, a person who lives outside the state of Alabama cannot serve. It has to be an Alabama resident if you die without a will. So the only way that you can have a non-Alabama resident serve if you name them in your will. Okay?
If you have a will, when you have an extra will like in nursery, when they contest the will because they were not named.
Okay, you have a will and someone lives.
Let's say my husband died,
Okay.
and he left everything to me and our son and myself. What happens if she decides she's going to contest it?
She being.
The ex.
Okay, the question is, what if an ex-spouse decides they want to contest the will? Generally, ex-spouses have no right to inherit from someone from whom they are divorced. The only right that an ex might have is some sort of claim against the estate for something that the ex failed to do. For example, if the ex was supposed to keep an insurance policy that paid out on his, well, not the ex, if a person is supposed to keep an insurance policy on his life that pays to his children from a previous marriage or pays to his ex-spouse, and he doesn't do that, then there may be some contractual claim there that you can sue.
Would their daughter have the right?
If there's some sort of, yes, a child, the question is, can a daughter, yes, a child always has a right to contest, yes.
If you have two siblings and one of them is the executor and one of them's a backup,
Mm-hmm.
and the one that's the executor anticipates he's gonna die,
Mm-hmm.
can he then appoint somebody to take his place before he goes to that alternate?
That's a great question. If you've got two siblings and you name one as the person representative of your will and you name a backup, the other one is the backup, and the first one anticipates that he's going to die, can he name a backup? Absolutely not. He can't choose somebody to be in charge of your estate. If he dies, then your other sibling is going to be the backup. If that person can't serve for some reason, then the court's going to appoint somebody. But your personal representative never has the right to choose who follows them. Okay. How long does probate take? I think we've covered this a little bit. A estate has to remain open a minimum of 6 months. That's that claims period that we talked about earlier. Most estates that I handle generally get closed shortly after that unless it's just really a problem with somebody contesting, or we've got some property to sell, or a business to divide up or something like that. But most estates are closed generally within a year or less. Now that's not always true, but I would say generally most estates I handle are closed in less than a year. So that's probate. Any questions about that? Probate is kind of the big mystery thing that nobody really understands what that is and why you have to do it. Just be aware that there are many times that everybody thinks their estates are not probatable estates. You assume that everything is jointly owned with your spouse so that when you die, nothing's got to be done. I'm going to tell you some things that'll catch you. Savings bonds. Any of you have ever worked and you bought savings bonds through your employer? Those are in your name only. I can almost guarantee you. So when you die, if you have a savings bond in your name only, that's a probate asset. There's also some insurance companies that several years ago issued stock to shareholders, to policyholders. If you had a policy with MetLife or Prudential, they issued you shares of stock. Those are issued in the name of the policyholder. Now, everybody thinks that because they have a beneficiary named on the insurance policy, that's going to take care of the stock, but it doesn't. I can't tell you the number of estates I've had to probate for 232 shares of Prudential stock. And that's the only asset that passes through probate. Or the $1,000 in savings bonds that the husband had in his name only. The other thing that we see that can cause probate between spouses is property that's inherited. If one of the spouses is inherited property from his or her mom or dad or somebody in his or her family, then it's likely it's going to be in the name of that person only. It's not going to be survivorship property, because a lot of times it's not your home place property. It may be a lot somewhere, an interest that you own with siblings in a family farm, that's a probate asset. So just be sure that you know how you own everything, so that there's not one little asset out there that's going to cause your spouse to have to probate when you die, when they would have not otherwise had to do that. Okay. Any questions about probate before we move on?
What would be considered advancement, where you have a situation where you've got two of the children that decide to have the parent pay them two or three children the money that is made off of the sale of the house that the parents owned prior to death. And they persuade the parents to pay them the money from the profit of the house. Is there a deadline of how long that can go back to be considered advancement?
It's a very interesting legal question. Mom and dad sell their house and one or more of the children say, why don't you go ahead and give us those proceeds now? When is that considered an advancement against their share of the estate? When you can prove it is. So if you are gifting your child something and you want that to be an advancement of their share, let's get it in the will. Let's get it in writing somewhere that you've made an advancement of that child's share, because otherwise it's going to be very difficult to prove that it wasn't just a gift, because gifts are not necessarily advancements against the estate. Are you with me on what an advancement is? You're getting part of your share early. That's an advancement. And you can't just assume that you can prove that just because a child got something, it was an advancement on his or her share of the estate. So the best way is that you put that in your will, that on such and such date I advanced Joe, my son Joe, X number of dollars, which is considered an advancement of his 1/3 share of my estate. Let's go ahead and reduce it to writing, get that in the will, so there's no question that there's an advancement of his or her share.
And you're saying how far back?
There's no how far back. There's just very technical rules on how you can prove it's an advancement. It's almost impossible to prove an advancement. Alan, you ever been able to do that?
Never.
Yeah, because it's always just that Mama gave it to me. She never intended that to be an advancement on my share. There's nothing in writing that says it is. She just made a gift because she loved me. She loved me better than you. So.
I could say the same thing.
Sure. Sure, yeah.
Then what do you do?
Everybody's just claiming Mama just gave it to me, so, you know.
That's why we have lawyers.
That's why we have jobs.
What is the derivation of the term probate? I mean, how did that happen? Because there seems to be a kind of a mystique about using the term probate and not really understanding.
Yeah, the derivation of the word probate, probate is the most misunderstood concept in the law. Every day people are afraid of probate. They've heard all these horror stories about probate. Oh my gosh, the state's going to take half of what you own if you go through probate. None of that's true in Alabama. Alabama's probate process is a very streamlined, clean process unless people don't get along. And the thing about that I want to just tell you up front about legal documents can't make your family get along. They just can't. There is nothing on earth that I can put in writing to make your family get along. Nothing. If they're going to fight and disagree no matter what the document says. I could spell out every single solitary thing you own and they'd still figure out how to fight about it. Well, she shouldn't have given you that. She promised that to me. You know, that she just loved you more. So a lot of these estate issues, and when you work in estate probate, you realize that it really has nothing to do with what the words on the paper say or who's getting what. It goes back to when they were 6 years old. And they didn't get what they wanted for Christmas, but their sister did. And they felt like that Mama loved their brother more than they loved them. And it's all those feelings that bubble up when somebody dies. And that's what estate issues are generally about. They're not about the stuff. Now, sometimes it's about the money, but a lot of times it is truly about these issues that we've dealt with in our families for years. You know, we're all dysfunctional, just in our own way. So it's all that dysfunction that comes up when somebody dies. That's what estate issues are generally about. I had an estate one time, I promise you, they were fighting over a toaster oven. A toaster oven. I wanted to go buy each one of them a toaster oven. It would have been cheaper for them to do that than to pay me to fight over the toaster oven. But it had nothing to do with the toaster oven, you know that. I had another estate where they were fighting over a piano. One of the people who wanted it didn't even play the piano, but by golly, he wasn't going to let his sister have it. There was no way on earth he was going to let his sister have that piano, because Mama bought that piano for her when she was a little girl. She wouldn't get him the thing he wanted, and he wasn't going to let her have that piano. So it has to do with feelings, and you can't make those feelings go away with legal documents. So just, if they're going to fight, they're going to fight. If they're not, they're not, no matter what the legal documents say.
So
Question.
how does an attorney adjust his pay? Because you can see $100,000 estate be so complex, take up more of your time than a $1 million estate that's just straightforward. So how do you?
That's an excellent question. How do attorneys adjust their fees based on the amount of work that's going to be involved in a probate? Because a very small estate can take up a lot more time than a large estate. Obviously, billing by the hour is one way to do that. You know, the more hours you got in it, the more you're going to get. A lot of times, attorneys know going in that it's going to be a problem. I mean, I can just usually tell when a family comes in. Now, I've been burned several times by that, thinking I know what a family's going to do. But generally, you kind of know up front if there's going to be a problem, and you adjust accordingly to that.
Should you review and update your?
That's a great question. How often should you review and update your estate plan? My rule of thumb for everybody, I wish you'd do it once a year, but I know you're not going to. Every 5 years. If you will just get your legal documents out every 5 years, get them out of that shoebox or out of that drawer where you've got them stuck, pull them out, blow the dust off of them, and just go down to the lawyer and spend an hour just reviewing beneficiary designations. Have there been any changes in the law? Have there been any changes in your circumstances? I can't tell you the number of clients that I've done documents for in the past, and they'll call me 4 or 5 years later and they'll want a new appointment to talk about assets, and we'll send them the letter that we need a list of all the things that they own and most recent bank statements, and they'll call and they'll go, oh, well, we're not going to bring any of that. It's exactly what we had back in 2010. Yeah, nothing about their estate has changed since 2010. They have the same exact number of dollars. They have the same bank accounts. Of course they don't. But we all think that things don't change in our life, and they do. So 5 years is a good rule of thumb, and anytime there is a major life event, a death of a spouse, a death of a child, the birth of a child or grandchild, a financial setback, a financial gain, if you inherit a lot of money from somebody, you move from state to state, any one of those events should prompt you to get your estate plan reviewed. It's just a good opportunity to take the time to get everything reviewed. Many of you have medical checkups. You go to the doctor, you get routine checkups. Make that a practice in your legal life too, that you just get a routine checkup. You may not need a thing done, but you may find something, aha, didn't realize I had not done this, that, and the other thing. Okay?
When you make a will, do you recommend that it be open-ended, say if you have an executor? Or would it be a good idea to put in a term that says it's got to be settled within 5 or 10 years to keep somebody from keeping it forever?
The question is, would it be a good idea to put some sort of clause as a time limit of when things need to get settled? It's been my experience that they can't wait to get it settled. If they're about to inherit something, I've had people call me on the way to the funeral home.
I've got one that's been going on for 30 years.
Okay, that one's unusual. His has been going on 30 years. That's unusual because usually when people are going to inherit something, there's somebody in that group that needs the money, and they're just going to be pushing to get it. But literally, I've had people call me before they even get to the funeral home to pick out the casket. When can we come meet you to get this thing settled? So that's more my experience than the dragging out ones.
How do you switch from lawyer to lawyer, say several years ago, you had a will done by a lawyer and you decided you didn't want to do business with that person anymore, and switch. What steps do you go through, or you just let it go and just come to whoever you want?
It's a good question. How do you change lawyers? What if you've gone to somebody in the past and you want to go to another lawyer in the future? You don't have to do anything. You really don't have to tell the other lawyer you've been to a new lawyer. All I ask my clients is if I've done documents for you and you're going to another lawyer to have new documents done, it's perfectly fine. I'm not going to get my feelings hurt at all. If you'll just call and let me know so that I can make a note in my file that the documents I have are not the most up-to-date ones. So if anybody is looking for the will, I don't think I've got the most up-to-date one. That's all I ask. It's just a phone call so I can make a note in my file. But you don't have to do that. There's no legal requirement that you have to do that. Yes?
Going back to what he said with his 30 years, I have a friend who's going on 10 years, and that's beyond the 5 years. What would the process be for any of those inheritors to go to their attorney and push for?
Yeah, be sure you understand what I meant by the 5 years. The question is, he knows an estate that's been going on 10 years, and he says that's beyond the 5 years. The 5 years is to start the process, not to finish it. You have 5 years to begin the probate process, not to finish it. It can take as long as it takes the personal representative to make sure everything gets done.
This is 10, they had started.
Yeah, I'm surprised that any estate would go that long, but I've been surprised by crazier things. So, just real quickly, I wanted to touch on living trusts before, because I promised a couple of you that I would say something about living trusts. I'm not the biggest fan of living trusts. They were popular for a while. Everybody thought they ought to have one. But living trusts is just a different path to the same end. When you've got a trust or a will, your end is to be sure that the assets that you have get distributed the way you want them. That's the goal. So is a will or a trust better? Neither's better. It's just a different route to get to that same end of the distribution. So do you need a will? Do you need a trust? It's up to you. I can explain to you which one does what, and you just decide which path you want to take to get there. The thing you have to remember with a trust is that anything that you want to be controlled by that trust has to be titled in that trust. So there is no point in you come into my office and I draft you a trust and you take it home and put it in the drawer like you do the will. It's worthless to you if you do that. Because the only way that trust can have any control over any of the assets that you own is if you actually retitle the assets into the name of that trust. So real property has to be deeded into that trust. If you want that trust to control your CDs, you have to go to the bank and change the title on them to the name of the trust. So unless you do that, you're wasting your time and effort doing the trust. Okay? So the only thing with the trust is you just have to be sure that you keep it up to date. All right? Thank y'all so very much. I appreciate all the questions. Thanks for having me back.
Ladies and gentlemen, thank you so much for watching and enjoying the program with us. Tonight we graduate. We've been through the People's Law School, and as it's turned out, some of our students have their own opinions and about what they think about the program. And I'm going to ask, for example, Gwen, what do you think, my friend?
I think all presenters did an excellent job and that the show should be rated #1 on cable TV.
Thank you. Thank you so much. And I see Mr. Martin here has got his, look at that diploma right there. Look at that thing. It looks pretty good. Have you enjoyed it?
Thoroughly enjoyed it. Learned a lot.
Thank you so much.
Miss Smith, did you have a favorite?
Oh, yes, you.
Oh! Okay, I wasn't begging for that. Did you have a second favorite?
I think they were all fantastic. I've learned a lot from each one of them, so it's been a great program.
Did you enjoy it?
Yes, I did very much. I learned some new laws I didn't know before. So I will be back.
I enjoyed it very much. Very educational and sometimes very entertaining.
Yes, I believe it. Now, here we go. What do you think about our program? Did you like it?
I did, and I thought a great variety of topics that were very practical were covered.
Thank you, thank you. And here we've got Mr. Jolie. His name is not Jolly, it's Jolie, like Angelina Jolie. And so he's corrected me earlier in the program, but what have you thought?
It's excellent, Alan. You've outdone yourself this time. This is the 4th time I've taken a course since I retired, and that doesn't count the 20 times that I watched it on TV before I retired.
Wow.
But it is just gets better and better.
Thank you.
Keep up the good work.
Thank you so much.
Did you learn anything useful?
Useful? A lot. I did not know what to expect. My brother and his wife had been attending in the past and had told me a little bit about it, and what they said was A+.
Well, I've always wanted to learn a little bit about the law, and this has really been helpful. I've been here twice, and I've learned a lot of stuff both times.
These attorneys, I really like them. They're professionals, and I felt like I could trust them if I needed their help professionally.
Ladies and gentlemen, I want to thank you so much on behalf of the People's Law School. Come back and see us. We're going to start again next year, and we'll see you soon.